This whole thing was organized by Dan Siciliano and his staff, and they have just done a remarkable job of bringing together the foremost experts in the nation to you. So I commend Dan and the Rock Center staff. I also commend my other co-director, along with Dan, Marcine Seed, who has just done another wonderful job for the second annual symposium. The two gentlemen that I have sitting with me have each played an important role in the history of immigration compliance. Carl Hampe was Senate counsel for the Immigration Subcommittee and was deeply involved in the drafting and legislative process which resulted in the Immigration Reform Control Act of 1986. I regard that as the birth of modern immigration compliance law. Carl is a partner at Baker McKenzie's Washington, D.C. office. Chuck Kuck, on the far side, is the managing partner of Kuck Immigration Partners, LLC in Atlanta, and very familiar to the legal community as one of the most dynamic of the American Immigration Lawyer Association's presidents. Chuck promoted the idea early on of immigration compliance auditing and appointed the first compliance auditing standards task force in March 2009. That same year, later that year, John Morton sent out the very first volley of 652 notices of inspection. You've heard that the system was basically silent for a few years, and suddenly in that one instant, that press release that those notices of inspection had gone out nationwide, the whole ambit of opportunities for compliance changed. The policy announcement that John Morton made in July of 2009 meant that basically the Bush administration policy of criminal investigations and prosecutions was at an end. But I don't think it's fair to labor the misconception that criminal prosecutions have ended. I think David this morning has painted a good picture of the very terrible consequences for employers that failed to at least realize that now compliance is a national required standard. We're in the new world of white-collar immigration investigations and forensic auditors. There's a new chapter in corporate governance, and it's being written here at Stanford today. The issue is whether corporate boards want contingent liability immigration violations sitting on their books. Dan Siciliano has told you that he's estimated that to be $104 billion. That's not chump change. That's real money, and that's real contingent liabilities that corporate America must face. Dan has also estimated that there's 7,800 companies that report to the SEC. Each and every single one of those companies needs an ethical immigration compliance program. Your company needs the compliance message now, not after you receive a notice of inspection. Sure, you get 72 hours, but what are you going to do in a 72-hour period when you have thousands of employees and I-9s to account for? Much has changed. Certainly, E-Verify is something we're going to have to deal with in the future if you're not already a FAR government contractor. Electronic I-9s are something we're going to be talking about later in the program with another panel. But we also know that state legislative requirements have ratcheted up. The Supreme Court is going to hear argument on the Arizona v. U.S. case April 25th. The whole world of compliance has changed for immigration. Carl, you played an important role in IRCA's legislative history. Do U.S. employers now have an enhanced responsibility compared to what you envisioned in 1986?
Chuck, I think the hands-down answer to that is if those of us young staffers and older senators and members of the House sitting around in 1986 drafting the conference report to IRCA could possibly imagine the apparatus that has grown around the IRCA statute and the employer sanctions statute, they'd all be amazed. My former boss, Senator Alan Simpson, with whom I spoke just a few weeks ago, was remarking on that. He said, boy, we never really imagined it would be quite come to all this, did we? And I think it was a mixed rumination, some of it much to the good, and at the same time some burdens on companies and on individuals that weren't imagined that have come apart. So it's a mixed message, but it is what it is.
You have thoughts about corporate immigration compliance in today's environment?
Yes, and if I may, can I?
Please, would you like the clicker? Yeah, that's the forward.
Power of the clicker. The power. Be very careful with that.
I thought I would speak to everyone just a bit about mine and my partner Paul Virtue and our firm's experience with where we perceive corporate immigration compliance to be. We certainly see it varying based a lot on the industry and the size of companies. As a general rule, the larger companies, the public companies, tend to just take compliance more seriously because they have chief compliance officers, they have layers upon layers of HR people, they have corporate counsel like us. And so while maybe immigration isn't quite at the top of their corporate compliance agenda, say the way FCPA violations are for global companies.
And the acronym is Federal.
Yeah, I'm sorry. The Foreign Corrupt Practices Act, so overseas anti-corruption compliance. Which, if you're looking for a red-hot corporate compliance item, I can't think of anything that's hotter right now. So immigration's not quite there. Nonetheless, a lot of companies just understand that that is an aspect of their compliance culture. We certainly see this desire to be compliant in this variety of areas, including immigration, as driven by the federal sentencing guidelines and their application to organizations and their the sentence reductions and the beneficial modifications to probation terms one gets from companies that have responsible ethics and compliance programs. And this is further institutionalized in the series of Justice Department memos. I'll say the McNulty memo, since that's Paul McNulty is one of my partners, but there have been a series of former deputy attorney generals who have memos named after them that say, look, here are the factors we're going to look at when deciding whether or not to charge a corporation. And as David mentioned in his presentation earlier, having an effective compliance program in place, it was one of the 3 or 4 C's or the 5 C's. That was a good thing to use, a good memory tool. An effective compliance program is one of them, and a lot of that really stems from the federal sentencing guidelines requirements. I think, as well as Chuck alluded, the public companies, the companies subject to Sarbanes-Oxley, the companies filing the quarterly and the annual SEC reports are required, even though the focus is sort of on certifying that their financial controls are in order, nonetheless are required to disclose any items that are material to their company's operation. And Director Morton mentioned Chipotle's issues, for example, not to pick on that poor company because I really like their burritos, but the fact that they're public, that they must make these disclosures, the adverse effects that would have on shareholder value, the additional liability that creates to them from a variety of perspectives, is yet another incentive when a company is in this sort of regulatory securities regime to have robust reporting requirements. And certainly the Dodd-Frank law, which is now being implemented to the financial services industries, is also going to drive that same compliance. And we see that with our clients. An area, if you're looking for the companies that are, these are both public and private, but the ones who would seem to be really to have the most heightened need for rigorous corporate compliance that's specific to immigration, I don't think you can go look any farther than the federal contractors. There are a lot of them that are headquartered outside of DC, so I think we have particular frequent interaction with them, basically because we can go out and have drinks with them. But many of them are public. They are prime contractors. They're responsible not only for complying with the FAR E-Verify requirements and prime targets if they fail to, but they have to put these clauses in their subcontracts. I mean, sort of wherever they look, they have a 360-degree requirement to be very compliant with the E-Verify requirement is sort of one thing, but once you start going down the E-Verify path, there's just a whole universe, a constellation of issues that sort of drives the way a company starts looking at corporate compliance with specific to immigration. These really are, the federal contractors, I think, are sort of the poster children for doing it and doing it right. And I would, if you're looking at it from big picture, I would sort of call this bunch the Group 1 companies, the advanced immigration compliance companies. But there's a Group 2 also. And this sort of goes to what Director Martin was speaking about. My hunch is that he would say they're trying to get as many companies as possible into Group 1, and they'll do it the nice way or the easy way, or excuse me, the easy way or the hard way from the company's perspective. But we have a number of clients in the Group 2 category too. And so just, they more often tend to be private rather than public. They tend to be smaller rather than multi-state. They just don't have that sophisticated corporate compliance infrastructure that the larger companies, frankly, can afford and, say, by SEC regulatory requirements must have. And so maybe they're sort of getting familiar with, okay, what is a chief compliance officer? What do they do? What kind of person do we want in this role? How are they really different than the general counsel? That's those issues that the big companies have resolved or are resolving. And ironically, or maybe not, a lot of these Group 2 companies will tend to be in those industries where a large number of low-skilled or unskilled employees are a part of their business model. They, therefore, are aware of E-Verify. They're aware that if they were to get a notice of inspection, they might have some issues. And yet, there are certain commercial factors that are just inevitably driving them, such as many of them know their competitors aren't using E-Verify or engaging in this level of compliance. And so they have to make difficult real-world decisions between the economics, between what their CFO tells them and their newly hired chief compliance officer or their GC. So maybe these are we can call them the struggling with immigration compliance group.
Let me ask you a question. There's struggling with immigration compliance. We know there's also the competitive factor you brought up. In Georgia, we had these two very large carpet companies. We're probably sitting on one of their products here today, either Mohawk or Shaw. Mohawk was sued by a smaller manufacturer because they felt that they were abusing these rules. They weren't doing I-9s, they weren't in E-Verify. And the 11th Circuit let that lawsuit proceed on Rico grounds. How does that impact corporate business? Is that kind of decision, do people understand that at the corporate level on these big companies? Or they just, well, hell, that's just Georgia. Everything crazy happens down there.
I can't comment on your second observation about Georgia, but
I can, unfortunately.
But I'm sure that's in your slides. But I think civil RICO is, after the Supreme Court decided the Mohawk case, and was more explicit about, look, you can't get a bunch of plaintiffs' lawyers just to dream up predicate felony offenses and cobble together a Rico case and have it stick. But it took a long time for that question to be resolved. And during the period of time when the question was unclear, look, there were some companies spent some serious money on defense counsel to make these cases ultimately go away. I would think after the Mohawk decision, it's taken less seriously. Beforehand, that was, you sort of added it to your list, right? If you were in a certain industry, there would be, there's ICE. If you're public, there's shareholder issues. If you're public or you're private, but if you're large, there's civil RICO. I would think the civil RICO fear is going down a little bit, whether that's fully justified or not. But let me just finish on image and corporate compliance, since that's been bandied about a lot, and I think there's some interesting things to be thought about here. There's this irony that the benefit of no ICE audits for 2 years is probably a little bit more attractive to companies in that group 2 still struggling with compliance category than the group 1. If you're in group 1 and you've got software, you're on E-Verify, you operate in 20 states, one of them's Georgia and the other is Arizona. Okay, so you're already doing E-Verify in those states, at least. You figure out, okay, E-Verify is not all that bad. And you've got a sophisticated I-9 software system, you've got all these people in your corporate infrastructure to make I-9 compliance work. All right, so if we get a notice of inspection, we'll be okay. I mean, it's not spotless, but is there a lot to worry about? I'm not saying, by the way, that I agree with their perspective. I'm just saying this is their perspective. So I think the incentive that Image offers of 2 years of no audits, it's not overwhelming. Now, in the group 2 category, that's actually a pretty good thing. But I think what they struggle with is, speaking candidly, I think in Director Morton's candor message, we'll just continue that message, or that theme, which is a lot of companies just don't trust ICE to do the right thing.
That's shocking, really.
And
so shocking.
Are you really going to rush out and do that? It's a valid question. Yet the benefits of no image, no audit is good. So let me conclude on these thoughts. What would, if you want more advanced immigration companies to join Image, the Group 1 companies, I think Chuck asked this question at lunch. Having ICE recognize the independent audits that large companies pay well-known accounting firms and consulting firms to do of a company's I-9s would increase the corporate interest in Image. Director Morton mentioned ICE would still want to look at things. Well, one thing they could do is ICE could look at the audit by the accounting firm, for example. I mean,
or law firm.
Or law firm.
Law firm.
Or whoever, or consultants.
Or lawyers.
You get good point. Or the law firm, yeah.
Right.
You mentioned the law firm that might want to do this? I'm not quite sure.
I got it now. So it doesn't mean that ICE wants to kick the tires, and that's understandable. I guess the question is, well, which tires can they kick? And maybe we can give them the front set rather than the back set that they're looking at right now. The second thing that would be helpful is, what is it that drives companies to comply? Well, it's a recognition that they have, for example, an effective ethics and compliance program under the federal sentencing guidelines. ICE could be helpful in this area if they would be willing to make some kind of statement. I understand this is a tricky, the wording of this would be tricky, but if they could say, look, if you've been in Image, we've done our audit of you, we've trained you, you're a compliant company, we're really happy to have you in Image. And if you're a company saying, hey, would you mind saying that in writing? And just saying that for the purposes of the federal sentencing guidelines with respect to organizations, your view is that on immigration, we have an effective ethics and compliance program. That's actually something tangible.
So you think that would truly build a culture of compliance?
Right. incentivize more companies to pay more attention to immigration compliance issues, and then drawing them into image would sort of enhance the discussion because they'd be interacting with ICE, and then I should be offering them something. I'm not saying that the 2-year no audits is nothing. It means something to some companies, less to others, but a certification as to their compliance with something, under a meaningful standard, such as the federal sentencing guidelines, is I could understand some of our clients thinking, well, maybe we'll think about it.
Excuse me, Chuck. We asked everybody to turn their phones off, while we're in but you did get a phone call.
No, he did not.
He actually,
he was that was her phone. But
no, Peggy, it's not your phone. It's really
who called me, Chuck? Who called me?
Yeah. It's your office. And
my office called me.
Your office called.
Yeah, I hate that happens.
And they have one of your clients has a question, and that is, the CEO of the company wants to know. He has a trained HR person that's been on the I-9 desk for 12 years.
Wow. Okay.
Wants to know if you're willing to train her to do an internal audit for the company.
I don't know if you heard my response or not to him. I did ask him what brand of marijuana he was smoking. If he thought I was going to train an HR person.
California. You don't want to go
there are so many of these training centers. I must get one email a week from some HR group saying, attend our training seminar on I-9s will teach you how to do an internal audit. And what's interesting about this is, who exactly are they training to do internal audits? The internal employees who screwed up the I-9s in the first place. A couple of years ago at an AILA conference, I speak a lot. If you're in New York, I can't stop that. I was at a conference involved in California, here was a California Campus Conference, and a senior ICE official even said specifically, I think it was that again this morning by Rachel, that if you audit your own I-9s and you just re-screw them up, we're going to come down harder on you than if you had an external audit. An external audit is a way to make sure that you are not only complying with the immigration laws, but I think it's a way also to lessen potential fines and to lessen external liability. So if the CEO calls me again and gets over my initial shock about telling me about marijuana in California, I would encourage him not to let an internal HR person do their own audit. Because I believe that leads to, more times than not, continued errors in the database. Well, there you go. Now, the whole idea of corporate compliance programs and bringing them into effect, I think the first thing you have to understand is you better have a written program. It's wonderful to go to a seminar and listen to ideas and take a couple of notes, but unless there's a specific program in place for corporate compliance, the one Image is talking about, when they're saying you must have an effective corporate compliance program in place, you don't have any other. What is that? What are the key parts of that component program? First of all, you better make sure you're actually doing I-9s. Recently, I got a phone call from somebody, a CEO of a small company, 100 employees. They got their letter. The ICE agent came in, wishing them a good day, said we'd like to see your I-9s. Here's our notice of inspection. Can we have them now? And at least he had the common sense to say no, because he called me and said, Chuck, what's an I-9? And they had no I-9s. 100 employees, no I-9s, not a single one. Now, to make it even worse for this company, the owner of this company is undocumented. So he can't even do his own I-9 and do compliance. He says, you know what, this is about a $4 million a year company. Guy created it from scratch. 100 employees, and so if we're going to do a corporate compliance program for him, first of all, he's going to fire himself, become a shareholder as opposed to an employee of the company. But begin to do I-9s. And you do I-9s now, you know that you're in big trouble with ICE, because now you have 100 separate substantive violations. But let's suppose you're doing I-9s. The first part of the corporate compliance program, do we have I-9s for every employee? It's amazing when you get into larger companies that don't yet have technology on their side. They don't have electronic I-9s. They may or may not have I-9s for every employee. They think they do. They're pretty sure they do. But unless you were putting together the current employee list and the employee list for the last 3 years and checking it against the physical I-9s they happen to have, you don't know whether they're truly compliant. So the first step is making sure that I-9s are on hand. The next step of that corporate compliance program is ensuring that they're not keeping I-9s they don't need to keep, and they're not literally throwing I-9s away. Went to an I-9 audit a few years ago with a federal contractor, right when FAR was starting, come in and do an I-9 audit, and the first thing they said was, don't worry, our I-9s are in great shape because our HR person, she internally audited us last year. And of course, you go through the I-9s, and it's not going to get a nightmare. And I kept seeing all these pieces of paper, these I-9s, with 2 holes up in the left-hand corner. You know, like staple holes, but there wasn't anything stapled to the forms. So I asked the HR person, "What? I noticed there's a lot of staple forms here. Did you staple these together at some point?" "Oh, no, we used to keep copies of documents. We throw them away." I went to a seminar, they told me to throw it all away, so I threw them all away. Did you have papers with them? "Oh, no." That's why we threw them all away, because we only had them for some employees, but not for all employees. We just said, we'll go the whole hog and throw them all away. All right, so we have a corporate compliance issue. What is your policy on I-9 copying? Obviously, when you verify, you've got to copy your documents. It used to be back in the 90s, we would tell, don't keep copies of documents. All they are is evidence against you. When the guy goes, how can you tell this? I can't tell it's not a real green card. It says made in China at the bottom. Clearly, it's a fake green card. Today, we say keep copies. The next part of our corporate compliance program is have a specific I-9 policy. Here's when we fill them out. Here's what happens if the person doesn't bring the documents back. Here's the training we do for our HR person. A lot of companies say, particularly larger companies, are on multiple sites. They might not just be in Washington, D.C. or Palo Alto, California. They might have an office in Palo Alto and one in Atlanta and one in New York, but they only have one HR person. So you have issues with remote I-9. What's your policy on remote I-9s? How are you handling the idea of a notary doing an I-9 for you? Who are your agents in those places? What do you have in place? You have to have these compliance policies set up, particularly if you're going to go image, but any good corporate citizen, particularly a public company, is going to have these in place.
And check, they're going to integrate into their hiring and promotions, the whole idea of anti-discrimination. We saw that the tension in '86 was that they wanted to make sure that on the one hand, there wasn't going to be national origin discrimination, or there wasn't going to be document abuse.
And now it inculcates into the whole corporate.
Absolutely. I find it interesting the comments earlier. There were no complaints for 6 years. Not a single complaint was filed in discrimination for 6 years. That's crazy. I just that must mean there's poor advertising going on for those 6 years, because you know there was discrimination going on during those years. It just apparently wasn't being complained about. But you're incorporating that entire idea of this specific compliance I-9s and the anti-discrimination compliance. Now, I would put an ad in there. Part of your immigration compliance program, let us not forget ththose companies that do H-1Bs and labor shirts. I mean, there's other compliance that goes along with as part of immigration compliance. You can't forget.
I think that's on the next slide.
You can't forget that. Now, but a couple more missing.
Yeah.
The next corporate compliance issue is, are you going to be an E-Verify or image employer? Are you going to do it? I routinely tell clients now to enroll in E-Verify. Well, I enrolled in E-Verify. My firm's in. Is it a hassle? Sure, it's a hassle. It's got to be a huge hassle for people to do a lot of hiring. Restaurants, fast food chains, it's got to be an immense nightmare. Now, I would make one comment. John Morton said earlier that one of the 186 companies out of 110 million employers in America that enrolled in the image program is Chick-fil-A. Okay, that's great. Now, how do you work with Chick-fil-A? Not the corporate, but different franchisees. I would tell you none of their franchisees know their own image. Because this is the first day I heard they were an image as a corporate entity. But those are all separately owned and operated corporations. So they would all have to separately incorporate and roll into E-Verify and image. So you have to develop the, are we going to do it? Is image a good idea for us? Is E-Verify a good idea for us? And I really do think images, and having read again what image is, this is not your mom's image. This is a very, very different program. I cannot believe they kept the same name, Chuck. I just cannot believe it. It's not the same program that
What
was.
is image spelled backwards? I mean,
I don't know. Igami. It's Igami.
Let's call it Igami.
The next step in corporate compliance is, are you going to go to electronic I-9s? Now, one of the huge benefits of doing the electronic I-9s is the automatic audit that comes with that. Because you're taking your paper and you're having to fix your mistakes. One of the nice things about the I-9, the electronic I-9 programs is that you can't make a mistake. You have to put this information in, so you're going to lose the ability to make mistakes. So then you can correct them as you go along. So again, part of that corporate compliance process.
Do you want to go to the next slide?
Yeah, let's go to the next slide here. Okay. The image verification. We have a whole panel on image commands. I don't want to spend a whole lot of time on this. But a couple of things that John Norton said today were really quite interesting, because he went far beyond what you read in the paper about what image is. The paper says, we've been auditing for 2 years. John Norton, I doubt we'll ever get to you. No, I don't know, that's what I got out of it. I doubt we'll ever get to you. Yes, we can fine you for 50% of the errors. I don't think we're going to do that. Well, we're going to look at 3 I-9s anyway. We can't look at all of them, we don't have time. We all know there's auditors, this whole audit compliance program that's out there right now. Do you know how many auditors are in the ICE office in your city? Do you know? I know how many are in Atlanta. Now, Atlanta's a sizable city, 5 million people. They have an ICE office, I mean, they've got to have 300 employees, easy, between the enforcement and DRO and stuff. I know they have 2 auditors. 2. I don't know how many I-9s you can review in a week without sticking a pitchfork into your head. But I bet you it's not any more than they can do at the same time. I mean, really, how many can you do? Ah!
On the next slide, Chuck is going to hold back.
Yeah. So you have a situation. How much work could they really do? How much could they really enroll in? How much could they really help companies in image? Are ICE officers really going to come out and review your hands, or are the auditors that are going to do it? We know why they hired auditors, because ICE officers hate doing this. One of the reasons ICE, the old IMS stopped doing it is they didn't like doing it. You don't get to carry your gun when you're doing an I-9 review.
Right on the next slide.
Yeah, go to the next one. So, push them along. Well, before I do that, no match letters.
And now this is like watching Seabiscuit run on a good day.
The no match, the whole no match issue. In every audit letter that ICE is, every notice of inspection, they're talking about every one of them, give us your no match letters. Now that was no problem last year because Social Security had to send no match letters out for 3 years, for 4 years. But now they send them out. And now that companies have them again, the question is, do they have is that part of their policy? How are they acting on the compliance? What are they doing with those no match letters? And this is why this external audit is so important, and not letting the internal folks do it. One, and particularly more lawyers than anybody else, we're involved on a day-to-day basis with the actual enforcement. Accountants aren't involved in the actual enforcement. Auditors aren't really noticed in the actual enforcement. So having a certified attorney come in who's been certified to do I-9 auditing, that type of thing I think would go a long way towards having a successful and valid I-9 process. And there's already a corporate example in place for a company that does this today, and that's Walmart. Now you remember Walmart, big giant company, really cheap prices. You all been to Walmart, right? What happened in Walmart, I think about 8 years ago? Anybody know? Remember? Paul might remember this little issue. Walmart had a little problem with cleaning staff. Possibly getting locked inside stores. Unclear about what happened, but we do know that the result of this was a $13 million fine. Now that's a lot of money. That was at least 4 seconds of profit for Walmart that year. Somewhere in that neighborhood. But what they did, that wasn't the important part of that audit. That wasn't the important part of the matter.
Downstream.
It was downstream. Because now what they say is everybody who contracts with Walmart, whether you're building a new Walmart, whether you're supplying balloons for their stores, you have to produce and be audited once a year by Walmart. And they make you produce your I-9 to them, and they make you carry a immigration compliance auditor who is an immigration lawyer in your country, but actually identify them in your written contract with Walmart.
And that truly did affect corporate culture,
Absolutely.
because all the major companies that had contractors and subs started to put into their purchase orders
they could look at it. They could look at
That
it.
same kind of language that Walmart was using. And then, Walmart, we'll go to the next slide. Walmart had a 10K that was shocking. When we saw the Walmart 10K,
I know the 10K is here, Chuck. You use magic filter. But this, the Walmart 10K speaks volumes about what
I know
happened.
this isn't a, I'll tell you what, we're gonna skip. Oh, I see, oh, tricky, magic slide.
Very, very good. I do remind you, you put the slide together.
I did, it's magic.
So, Walmart, so here's a question for you. Think about it. You're saying, well, if we do this really nice audits, 3,000 a year, it will really impact corporate culture. But what had a bigger impact? ICE coming in and publicly embarrassing Walmart and making them pay a fine, or, hey, we're going to do a little audit on content way we're doing this. I mean, sometimes the big bang, I think this was kind of a Bush era idea, the big bang gets more attention than the nice corporate compliance stuff that you do.
So that CEO, what he really needs is he needs a whole I-9 policy, training, manuals. He needs the whole compliance program.
It's just not going in and spending an hour with an HR person and say, here's the 43 different ways you can screw up the world's most complicated one-page form. I mean, that's what, when they want you to come in and train your staff, that's what they're asking you to do. They're asking you to transfer all your knowledge about how you can screw the system up and how to fix it to a person that has no real significant training or experience, despite the fact they've been filling out an I-9 for 12 years.
I think, go ahead, Carl.
Can I just underscore one thing that Chuck was talking about in the Walmart case and contractors? One of the sleepy issues out there, we think, is a company's, there's an ICE best practice that says you should know your contractor. And in the Walmart case, Walmart settled because of actions taken by Walmart's contractors. They're overnight janitorial contractors. And so the IRCA clearly has a contractor provision where you can't enter into a contract in order to avoid the employer sanctions requirements. But I think we're beginning to see now the expansive reading of that contractor liability situation. And let me give an example that I think is a little more relevant in the Silicon Valley, which is if you outsource, large companies, large tech companies, large financial services companies outsource significant portions of their work, right? Data processing, data entry, for example. Those companies tend to be global. You could, if you're aware of it, if you know what those companies' practices are and if they're problematic, be held to having some kind of responsibility for that contractor, or at least if you were following the ICE best practice, you should know that contractor. And the example here is the Infosys case, where there was a civil lawsuit which turned into, I think, Eastern District of Texas investigation on, okay, well, what was going on with Infosys? And we heard about it because some of our clients who outsourced to Infosys got subpoenas about Infosys.
That's a good way to find information out.
Yeah, and so contractor liability and one's responsibility for, you don't want to get too into a contractor's business, or there's a joint employer issue. On the other hand, completely disregarding what your contractor is doing is another area of potential risk.
It just occurs to me that I get to hear one of what Washington Post called one of the best immigration lawyers in D.C. That means the country. I appreciate your point of view. What I wanted to do for the balance of our time is you got the book, and I wanted to, for the balance of our time, explain how to use it, because it's an integrated auditing system, and I think that if I didn't give you at least an owner's manual spin around the book, you'd go home and you wouldn't necessarily use it properly. What we basically did was we took the period of time after IRCA, which was 25 years, we took the 15 years after the Virtue Memorandum, and we took the current OCAHO case law, we took the regulations, and we took the current ICE policy. We took the virtue memorandum substantive list of substantive and technical or procedural violations, and we updated it using the ICE 2009 penalty memoranda criteria. So what you basically have now in the book is a composite list of the updated virtue memorandum. You also have an I-9 checklist, and that's, I'm going to discuss that in just a minute, but you also have an auditor's guide. The auditor's guide takes the symbols. We broke down the virtue memorandum, the composite updated virtue memorandum. We attached symbols to it, and then what we did was throughout the rest of the book, we refer to those symbols. And those symbols are substantive or technical or procedural violations. The actual virtue memorandum, he's sitting right here, I'm going, virtue memorandum. The actual virtue memorandum has been out of print for years. We actually found it. I found it in my library. One of the great things about paper releases, well, yeah, it was an interpreter releases.
Paul has it framed in his office.
He retyped it, and it's there with all the appendices. What I'm going to do now is show you. This is one of the tables that's in the book. There have been 6 versions of the I-9 since its rollout in '87. The current one is the 2009, which has the document reduction list A, B, and C. The 1991 I-9 was good for 16 years. So if you're an auditor and you're looking at the I-9 form, for that broad period of time, the agency gives you the discretion to look at that 1991 version of the I-9. The other crucial date that an auditor is going to remember is September 30th, 1996. It's not Paul Virtue's birthday. September 30th, 1996 was the enactment date of IRA. And why that's significant is before September 30th, 1996, any timeliness violation was considered substantive. After the enactment date of IRA, it became a technical violation. The great thing about ICE today is they're recognizing all these policy changes. So you're getting a real accurate look at what ICE is doing when they're auditing. The forensic auditors from ICE have a much more limited purview. They're looking for, of course they're looking for a substantive violation. As Marcine said today, one substantive violation on an I-9 is a count in a complaint. One substantive equals one count in one complaint for one employee. So now you have auditor training, so you got your $149 worth. No, we don't have to go home yet. No. The other important date to remember is April 30th. It's in the book. You don't have to pay attention. And it's also being videotaped, so you can go home and watch this, curl up with some... You have to be really bored to watch this. April 30th, 2009 is the effective date of the document reduction. So the list, the current list, A, B, and C that's on the 2009 I-9 has the document reduction built in. Can't ask for more than that. The next slide, here's my favorite. This is the modern immigration compliance audit that is discussed throughout the book. It's not merely an I-9 audit. As Chuck Kuck told you, you're not only just looking for I-9 irregularities, you're also looking for liability. Marcine wrote the chapter in the book, and what she put in that chapter is it's not just I-9s, it's also your benching, it's your public access, your LCA problems with the H-1Bs, it's your PERM violations, it's your anti-discrimination. At the end of the day, when Dan Siciliano said that there's $104 billion worth of I-9 liability on the books of corporate America, I think there's more, because I think there's also other liability from all these other amalgam of potential penalty violations.
If you find any errors in that chapter, then Chuck wrote it.
Okay. The compliance program audit is what Chuck Kuck just talked about. They're going to look at the programs of the employer for anti-discrimination, for proper training, update your manuals. Is HR and executives being included in the training? Anti-discrimination, we're not going to forget about that because that is a very big issue for the employer that finds themselves either in the EEOC or in a 274B proceeding before Judge Thomas. The line is 15 or more employees for that jurisdiction. We're doing pretty good on time. I wanted to tell you more about this particular, we're going to go past that. There we go. That's the crux of the book. It's it actually appears in black and white on page 138 to 139. When I was talking about the composite list of the virtue memorandum, that's it. If you look at it, the pink or red is the substantive violations. The green is the technical, right? Section 1 is the orange. Section 2 is the blue. Section 3 is the yellow. Okay? Brown is your knowing violations. I think we call that K1, K2. Knowingly hired is the first. The second one is the continuing to employ. Folks, if you take anything home, just remember, Section 3 is not a paperwork violation. It's by statute. For the lawyers in the crowd, remember that read the statute first, then the regs, then the Okaho cases, then the policy. And I'm telling you that Section 3 is not a paperwork violation, but it can be a knowing continuing to employ or a knowing hire. And that's where you get into serious trouble. That could be 10 hires in a year. Chuck, what happens?
Showtime, my friend.
That's right. And what happens if, and remember,
Up the soap, man.
when David was talking about forfeiture, there were two big whammies that were discussed. Number one is forfeiture. I'm sorry you didn't talk about tax evasion. You know, that's the Al Capone rule.
That's the one he's not supposed to tell anybody about, Chuck.
But honestly, for Al Capone rule. Honestly, the forfeiture, any Title 18 violation can be subject to forfeiture. David talked about the harboring in an apartment house of the restaurant owner. That apartment house is seized. Chuck, what happens to where does that money go?
It goes to the Treasury, actually. That's the one thing that's interesting about all these fines and stuff. They do not go to ICE, which is crazy. You think they would say, hey, put them in our budget so we can get more auditors. No, it goes back to the general fund.
This guy's more fun. These two guys are my dream team. Remediation, if I have to tell you what's the most important single theme of the book, besides the virtue memorandum, of course, is remediation. ICE is recognizing remediation. Okaho is recognizing remediation. What is remediation? It's the correction of I-9s in a timely fashion before the notice of inspection.
Before the notice of inspection. Let me ask you this question, man. It's part of an immigration compliance strategy that's enacted after you get the notice of intent to notice of audit. Is that effective at all?
Look, folks, you companies out there, you have an ongoing responsibility under the statute, under the regulations, to maintain and verify and continue to do that. You have to continue, and I think you need to remediate, but never backdate. And if you're going to remediate, I think Rachel Ross this morning actually gave you some good tips. If you do a private audit, if you hire Chuck's firm to do a private audit for you, he's going to give you a report. First, he's going to give you a report of remediation, what needs to be corrected on each individual I-9, so you get credit for it. The other thing that he's going to do is he's going to come back later and he's going to check to see whether it was remediated properly. Then you're going to have a population of I-9s that can go forward. What can you do with that population of I-9s? You can transfer them electronically. You can join E-Verify. You can join Image. You're going to get credit for being a compliant employer.
Now, on the remediation, I would, earlier somebody had talked about, you get the notice of audit, and you don't have all numbers, or they're all garbage. Do you remediate at that point? My answer is yes. You absolutely remediate at that point. The last thing you want to do is on day 4 say, we don't have anything. And what did you do? No, we're not worried about that. No, you definitely want to be there at that point.
Judge, I'm sorry, go ahead.
Just to add one thing, on remediation at any point, but if you know you have a problem, and either ICE isn't there, but they may come, or ICE has already been there, it really is at that point where calling in outside counsel becomes critical. Absolutely. Because to the extent you do an audit, the audit is supervised by a lawyer, it's subject to the privilege. Mm-hmm. If there's any expectation that this could come under scrutiny of a government agency, then the raw results from your company's internal audit is fair game for discovery. And, so they can subpoena it, and that's it. You sort of, your HR director's musings about, wow, gee, that office in Dallas is really weak. Okay.
I got to tell you a story. We hired a retired U.S. attorney to work in our office, and the first thing the guy ordered was a work product stamp and a privilege stamp. And every document that guy touched had privileged in. I loved it. I loved the justice. What? Yeah. You put a stamp on it?
No, so the company should have the ability to decide whether the results of its audit gets turned over to the government or not. You might want to. There's a strategic reason for doing it, but it's a privilege. But the privilege is held by the company can waive it if it wishes. But if you had your internal staff do it, and you particularly didn't involve your in-house GC, where there's arguably an argument that it's privilege, then, it's fair game.
The last thing I wanted to talk about was the Ron Gotcha rule about the statute of limitations. The statute of limitation runs on paperwork violations until the I-9s are corrected or the employer is no longer required to retain it. For knowingly hired or continuing to employ violations, it's the termination of the employee. And here's the kicker. The statute of limitation for timeliness violations runs the next day from the reporting requirement. So for Section 1, it's the next business day. For Section 2, it's 3 business days. But also remember, we talked about the September 30th, 1996 IRA. Before that, it's substantive. After, it's technical. I think it's very important to remember that timeliness violations under the Virtue Memorandum are now technical violations. And that's my final thought on the subject. Ron.
I just have a quick question for Carl. Just to clarify something. Folks here who are attorneys and also me. Happy to be an attorney. If you waive privilege, don't you have to waive privilege completely? You can't selectively waive privilege?
This is such a murky area. You could certainly say with respect, if there's an ongoing immigration investigation, it'd be interesting to see if the Justice Department representative sees eye to eye with private sector counsel on this, but you could certainly say, look, we're waiving with respect to this. The various, McNulty memoranda have, these memoranda have changed the prosecutor's perspective now so that they're not counting a privilege waiver as cooperation. So they can't discount a cooperation score if you don't waive privilege. And then you have a conversation with them about, I think you'd want to talk to whatever office you're dealing with and saying, all right, we'd like to make this disclosure. Let's come to an agreement on the extent of our waiver.
I'm just concerned about the situation where you waive it with respect to the external audit, and ICE comes back to the subpoena for all companies confidential.
I tell ICE to take a fly in the leap, we're not going to give it to you.
That may be outside the scope of an administrative subpoena.
I would love to hear from counsel.
That's the answer.
I'd like to hear from everyone's perspective on this.
I think it's a practical matter when you're talking about corporation waiving the privilege. One is Carl mentioned, we are not allowed to ask the corporation to waive the privilege on the Morford memo. And to the extent it's done, it's not going to be a usually something pretty narrow that we want to look, not grasping, but will come up.
We'd love to see it.
And you know, and in order to show that important C, cooperation, outside counsel will sort of, you know, agree to turn it over to try to score points as far as being cooperative.
And David, it also depends on the stage that we're talking about and what kind of subpoena. I think if you're talking about an IRCA administrative subpoena, which would be part and parcel of the administrative inspection, that's going to be an IRCA subpoena, which is basically an administrative subpoena that has to be relevant to the ICE audit. Going after emails and stuff like that, they'd have to go to federal court because Chuck Kuck would never release that stuff without them going to federal court. Yeah.
No, I understand that, but ultimately a federal judge is going to weigh in on it. I just look at it.
But they'd have to get a regular subpoena ducis tecum, or they'd have to get a regular federal court subpoena as part of a criminal investigation.
You know, dealing with sophisticated defense counsel and outside firm, we actually signed informal agreements saying this didn't waive privilege, and we even had some language in there about being limited to this particular subject matter for issue of inquiry. But you know, there's trust there too. And when you're pre-indictment, just as a practical matter on the criminal side, at least federally, it's not very adversarial. Everyone's kind of trying to get along and usually feel these things. But that is, yeah, I mean, obviously something to be careful.
Let's all move to the Southern District of Houston, I said. I
think it's pretty universal, actually.
I was going to say, we need to wind up, but I wanted to stress what the ethical immigration compliance audit really is. It's according to the statutes, Homeland Security regulations, and ICE policy. So you have to factor that in. In our book, we talk about the Generally Accepted Government Auditing Standards, GAGAS, which is the auditing standards government auditors do for their own programs. The ABA rules are of professional responsibility, are model rules, but each state bar has its own rules of professional discipline. And any attorney auditor is going to be subject to the state bar rules of the jurisdiction. We took into account what financial auditors do and their accounting oversight board. In the book, you're going to see a good discussion that Chris Starr wrote, there he is, about principles of auditor independence, competence, attestation agreements, scope of audit, reporting of fraud and illegality. So many of the questions that you have require that type of framework. When you look at it from an ethical, principled approach, many of the questions can be answered by that type of analysis. So there's your ethics 1 hour. And I want to, again, thank Dan and Rock Center for the hospitality, and thank you for your kind attention.